Shall I start?
Yeah, you can.
Okay. Thanks for joining us. It's a pleasure to see you all in this hall. And today our topic is about money, investing into game studios, and we'll try to explain how to give money and how to take money and what the issues are behind these two situations.
Today we are going to go through the main topics that that actually matter in getting investment and in giving the investment. So we will make a short intro about the two of us and explain why we always walk together and work together. We will introduce forms of investment that are the most popular, and then we will talk about issues or possibilities.
So first things first, a short intro. So please welcome my colleague Giedrė.
Hello. My name is Giedrė Čuladienė. I've been working with investments and M&A for all my professional life, which is not that short already, over 15 years. And we want to say why I'm speaking about investments and why Aurelia is so passionate about IP. And the reason with me is that I just want to get the things done. All that matters to me is to get the investment, to assist in getting the investment and in giving it, and I don't take the answer no. But this is only the beginning, so here is where Aurelia comes.
So as you already know, my name is Aurelia, and I'm an IP lawyer, and I am here or in every deal related to gaming industry to secure the value. You probably understand and know that the only thing that every game studio has actually, or the money generating thing that they have is their IP portfolio. So my role is to ensure and to stand behind or step ahead of the investor and game studio to ensure that the IP within the deal is allocated rightly and securely. And this set of combination, or our skills, my and Giedrė's skills, are usually needed in every deal, M&A deal related to gaming, because, well, yes, she brings the investment, and then I secure the value in the investment. Besides that, one more thing in common is that the only video or just the game that we ever played is Tetris, hence the visuals of our presentation. But leaving the jokes behind, actually, no matter how old the game and how complex it is, the legal issues are quite the same all the time. The issues that we have to deal are quite the same. So let's see what are those issues here.
Yeah, so we will start from the forms of investment, and here we should think in the way that the investors think. Usually what they care about is where the investment goes. So this is basically the team and the IP that it creates. So in in every issue, you have to think through those two dimensions and to check if the team is in place, which creates the game, and if it has the IP, and is it collected in the same place where the investment goes. In every issue that you consider, you should start with a question, why do you do that? What is the goal of the investment? So actually, the actual goal is receiving the money in the end, but starting from the purpose of the investment, the purpose might be different. So it might be to create the game. If the team does not have resources, financial resources, it should get the money for creating the game, for living life during that time. The other purpose might be publishing. You have already the game in place and it has to be published. maybe the game should be integrated with other products that the investor has. Or maybe the investor just wants to develop some infrastructure that is used for games, for example, VR software. So having this in mind, we have several forms of investments that are usually used in practice. And the first one, I think that it's one of the most popular forms, is revenue sharing. So since this form is related to IP more, Aurelio will proceed.
Yes, usually when we have revenue sharing, IP issue is the key, and it's because, this form is loved by publishing companies. And legally speaking, it's a joint venture agreement or agreement, some kind of joint venture agreement where the publisher gives money. Also, it gives assistance in marketing of the game, also certain assistance in distributing the game either through the publisher's resources or through some kind of platform or etc. Whereas the gaming studio gives its IP rights, also human resources, those who are developing the IP. And in exchange, the parties agree on certain fixed period of revenue sharing. As publishers are really interested or concerned that the game would in their portfolio would be successful, they are usually more active in this particular form of investment. They are they usually have the voice in what actually goes into the game, from mechanics to the visuals. They also are keen in promoting the game and putting the resources that they actually have. And then the second form
is the equity. So this form is usually used by those investors that do not really involve that much in the creation of the game. So here it's more specific for the venture capitalists, for business angels, because they just give the money and then they share some kind of experience, but they do not really involve that much in the process. So equity form is basically acquiring the shares of the company in the proportions that are agreed with the founders. And here, I think that it's worth mentioning that getting the shares, acquiring the shares is easy. You can do it on one-page agreement and complete the task. But the whole game starts when you want to do something afterwards. For example, it's not possible to just simply buy out the other shareholder shares. You have to agree on that firstly. So the main document that plays this role is the shareholders agreement. So getting the shares is easy, but then you have to agree on all of the scenarios that might be of interest in the agreement.
Okay, and the success stories that we have.
And we just wanted to list some success stories that are available on internet and show that these two combinations of the investments are really used in the companies. So starting from investments in early stage are followed by big buyouts, and these are the examples that were made public, but I suppose that there are much more that are not really public.
Okay, and we also said at the very beginning that we would talk about the issues as we see, as the lawyers see them, and the possibilities as the business sees all the issues along the path. First thing, what I see, it is essential to gather all your IP into the company that is seeking for the investment. And this is the main thing and main homework that you have to do. What I mean by saying IP, it's copyrights, it's trade secrets, it's trademarks and patents. When we talk about the copyrights, we talk about the source code, about the characters, about the script, storytelling, and things like this. And the copyrights are for the protection of expression of your ideas. Trade secrets, it's the lists of your clients, potential business partners, also the ideas that you have while creating the game, or you exchange while creating the game. Trademarks, they helps you to have a certain identity in the market, and via trademarks you can protect the words, graphics, short phrases, names of the characters, 3D marks, sound, color, etc. And patents. Patents are not that often in gaming industry because usually it's really difficult to patent any source code, but maybe some strategies, maybe some making the game to be played easier could be patentable.
Maybe I can add one thing here. For the investors, as I told, it's very important to have a team that creates IP, that creates the game. And usual thinking of the founders is that I have created the game, so this is mine. But here, this thinking should be changed, because all the IP should be collected not by the natural persons, but by the company where the investment is actually put. So you have to collect all the IP, make agreements on transfer of the IP, and this is normal.
And, well, oops, I'm getting back. And what could go wrong here? Quite a lot. If you do not have the proper documents showing your ownership, then it could lead to the dispute to whom the ownership belongs. If you would not make a proper audit before investing, you could invest in the game that has underlying IP issues, and then again the disputes come. If the game that you are planning to invest or seeking for investment would use some copyrighted material that it's unauthorized copyrighted material, again, you would face the claim. If you have IP rights that are registerable, it's patents or trademarks or sometimes designs, if you do not register them at the right time, then theoretically you can have the situation that you have an IP right, but you cannot protect it because it's not registered. And also, if you are using or IP created by third parties, make sure that the gaming studio that you are investing in, or the game studio that is seeking for investment, does not breach the license agreements, because again, the problems might come.
And I want just to draw your attention where the law comes as an enemy. Even if you choose the applicable law, or even if you choose to establish in some particular country, if you make the agreement with the investor which is in another country, still you have to check which law will be applicable, and to check those rules that will apply anyway. So as an example, it might be that, for example, in Lithuania, if an employee works in the company, the employee creates some IP. This IP belongs to the company only for 5 years, in most cases, and then goes back to the employee. What does it mean? That this employee might come after 5 years to the company and ask for additional remuneration. And this would apply to anything, because IP is not only creating the game, but also making some changes. So this is one of the rights which is which would also belong to the employee if you do not have those provisions in the employment contract. Then the second regulatory challenge would be joint liability. So in case of revenue sharing, usually the liability is joined by all the partners. So what it means that if the investor comes which only gives money, he's not interested actually in accepting more liability than the money it gave. And then the ownership, it relates both to the shares that are divided by the founders and the investors. So it's very important, as I said, to agree on the scenarios, what will happen after the term when you want to share the revenue. Or in case of revenue sharing, IP is important because when you act together, it's very important to agree who will own the IP after the cooperation. So basically, these are the three major challenges.
And I would elaborate a bit more about how IP is allocated for each form of an investment. So when we talk about revenue sharing, usually the IP remains with gaming studio. And also we have here a fixed period of cooperation, after which the parties separate and go do their business on their own. When we talk about equity, IP is gathered or buckled into the company, and the investor, while acquiring some shares in the company, he also acquires a portion of IP. But you should not be, as a gaming studio, you should not be afraid of the situation, because you remain also the shareholder in the company, which means that all the decisions are made between or collaborating between you and the investor. And if the investor comes out of the company by after buyout or something like that, the IP remains in the company, and still, since you have shares, you can control it. That's about it. Please visit this resource that we have on our website. It would lead you to the legal guide to the gaming industry and many more interesting things for the young companies. And feel free to download and share it with your peers. And now we have a time for your questions and our answers.
Can you get back for a minute?
Yes, sure.
Thank you very much for the presentation already. I gather it's amazing, really. I'm pretty sure we have a lot of questions right now, so who's going to be first? I can't believe you know everything, come on.
So maybe I can start with just making the main points of this presentation is that in every matter that you make, firstly, both parties have to understand the goal, and it should be common. So when you understand the goal, you can take any forms of investments that are suitable for the situation. So firstly, the goal, and you have to know that the team and IP is that really matters.
Okay, thank you. I wanted to ask you one question. So when an investor invested in some company, in some developer, is there like some benchmark, somehow again tools maybe, how they measure the success of the investment? If it's a little bit different from you were preparing to.
Well, how they measure. In case of revenue sharing, usually the parties agree on some cap of the until which point the revenue would be shared. So usually it's triple, or maybe it could be 5 times the investment, and then the investor comes out. So yes, if you gain what you've planned, then the investment is successful. Okay. And what about equity?
Yeah, the same. Usually, what the investor agrees with the founders, they just cap their either revenue or the term, and then give back the shares to the founders. So the same, either the money
Okay.
or the term.
Okay, understood.
Thank you for the presentation. I have a question. This process, how is it different for just like regular technological startup versus gaming-related, accelerated gaming incubator?
Equity is basically the same for all investments, but then what is not really typical for other startups, industries, is the revenue sharing.
Yes, usually because for the technical companies, usually what comes into the investment, it's either angel investor or venture capital, and they would as a rule, choose to have equity in the company. And the specifics here is the publishers that use different form of investment.
And there's one more thing that technological startups have also other forms of investments that are also sometimes used in the gaming industry. They are not that popular, but still they somehow interact.